The regular scheduled meeting of the Collection Service Board. It is 9:30, so we'll go ahead and get started if the chairman would so desire.
Okay.
All right. Let me first off go ahead and read the notice of meeting. The notice of February 19th, 2020 meeting of the Collection Service Board meeting was posted to the Collection Service Board website on February 7th, 2020. Since we're doing a teleconference today, I'll need to read the statement of necessity, and then we'll have to do a roll call vote for any actionable items. Okay. So first of all, let me take a roll so we can establish quorum. Bart.
Here.
So we got Mr. Howard. Great. We got Angela Hoover. She's absent. Josh Holdman.
Present.
All right. Thank you, sir. And Chip Hellman.
Present.
All right. Great. We have quorum. Statement of necessity is as follows. According to TCA 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body, the governing body must file such determination of necessity, including the recitation of the facts and circumstances on which it was based, with the Office of Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 844-108A3 defines necessity as matters to be considered by the governing body at the meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is the regularly scheduled meeting for the Collection Service Board, and the purpose of today's meeting with a couple of the members attending by teleconference is to discuss the agenda as noticed on the website earlier. Again, I'll have to remind everybody that we'll have to do a roll call vote for any actionable items. Our first actionable item will be to accept this statement of necessity. Do we have a motion in that regard?
I'll make the motion.
All right, we have a motion from Chairman Howard. Do we have a second? Is that Mr. Hellman?
Yes.
All right, we have a second from Mr. Hellman. Roll call vote then. Mr. Howard?
Aye.
Mr. Hellman?
Aye.
Mr. Holden?
Aye.
Great. That's passed then. Moving along to the business at hand, the reason why we all gathered this morning. So we'll get on with that. November minutes. I trust that everyone had an opportunity to look at those. Are there any edits or comments in that regard?
Not from the chair.
All right, nothing from the chair. Gentlemen on the line, is there anything?
No.
Okay, then we'll entertain a motion to accept the minutes as written. Do we have such a motion?
So moved.
Is that Mr. Hellman?
Hellman.
All right, great. Mr. Hellman has given us a motion to accept the November minutes. Do we have a second?
Second.
All right, we have a second from Chairman Howard. For roll call vote, Mr. Howard?
Aye.
Mr. Holden?
Aye.
Mr. Hellman?
Aye.
All right, great. That's passed. Moving on to the director's report. We'll just go over the budget real quick. Not a whole lot to discuss. We went over the reserve fund and this fiscal year through September at the last meeting in November. So for this meeting, we'll only be looking at really 2 months. That's the only months we have in since then. So not a whole lot to discuss. October received a credit under administrative cost-backs due to a reduction in licensee numbers, which resulted in a reduction in cost-back percentage and subsequent credit for that quarter. So if you see that credit, that's what we're looking at. Because if you look at the administrative cost-backs across the board, we have a debited all across, but then October we see a credit. As you know, administrative cost-backs are basically anything that normally would fit under the Edison line items, but doesn't have an itemized section. So it's just, and that's figured on the budget plan, the number of licensees and the complaints. So if we see a reduction in licensees or complaints, then our administrative share of the total cost that would normally be distributed across all of the boards is going to be reduced. So each quarter they look at that to make sure that that budget plan is consistent, and that's being debited accordingly. So this quarter we got a credit. So each quarter we'll keep looking at that to make sure that that budget plan is appropriately making those considerations and that everything is distributed fairly. But just real quick, it looks like we're tracking in the black. That's where we want to be. A couple years ago, we went through a brief period where that wasn't the case. So everything's been trending nicely since then. We're looking at a total year so far this fiscal year of revenues of $79,600, and then debits or expenses of $32,000, leaving us a net surplus of 47,600. Things look good. If there's any questions, of course, I'll entertain those, but this is just for informational purposes. Any comments or questions in that regard?
I don't have any comments about the report here. Do you know how many licensees we have? How many people are licensed?
I don't off the top of my head. That of course that number fluctuates. We have seen a diminished or a decrease in that regard, but not substantive. So a lot of folks taking advantage of the exceptions, or the exemptions rather, kind of educating themselves in that regard, or combining licenses where they don't need multiple license numbers. They can do it underneath one. So things like that's happening. But I think we've already had that correction.
Yeah, I think that happened a couple of years ago.
Yeah, that seems like that's leveling off. But it's somewhere, round figure. And Bob, you may have to help me out, but I think it's somewhere around 1,000 or just under that.
Okay.
So, but I have so many boards, I don't know off the top of my head but it's somewhere in that range. All right.
Make a motion that we accept the budget report.
Well, I think we can move on. That typically we would that would be an actionable item for under the director's report, but the budget I think will just be informational purposes in this regard, since we're not actually going to make any allocations. So I think we're safe to move on to election of officers if that's okay with everyone. All right, great. I'll just read the statute. In that regard, it says basically 6220-104E, the board shall annually select from its members a chair, vice chair, and secretary. No member of the board shall hold more than one such office. And this being the first meeting of the year, we'll need to make those selections. So we're looking at, again, the chair, vice chair, and secretary. We know Steve Harb is no longer on the board. He's since retired, and I think enjoying a few more, opportunities fishing and golfing and the rest. So I don't know that, he won't be on the list this time around, but it'll be us. And then, of course, Miss Hoover, she's on her second term, and she expired last year. She's, thankfully has been attending until we get another appointment. But I can't say for certain that she'll be back on the board for another round. So, gentlemen, I believe it's you three. So if there's any nominations in that regard and in some particular order, they could be entertained now.
I nominate Bart Howard as the chairman.
All right. And then that's Mr. Holden.
I'd second that. Hellman.
All right. Well, let's, do you have any other recommendations? Maybe we can just do them all in one package. Mr. Holden, do you have a vice chair?
I'd nominate Mr. Hellman for vice chair then.
All right. And then I suppose you'll be secretary then by process of elimination.
Okay.
Okay. All right. So we'll accept that nomination then. Mr. Holden then has nominated Bart Howard as the chair, has nominated Mr. Hellman as the vice chair, and then he will serve another term as the secretary. Do we have a second in that regard?
I second.
All right. Thank you, Mr. Hellman. We have a second then. For roll call vote, Mr. Howard,
Aye.
Mr. Holden,
Aye.
and Mr. Hellman.
Aye.
All right, congratulations. We didn't have to wait on Iowa and New Hampshire this year, so good job. All right, so that order of business is out of the way. We'll move on to the Nakara Conference. As you know, each year, the Nakara, or North American Collection Agency Regulatory Association, as it's called, is the professional association for regulators, and also for the industry as well. They do a sort of a section for the industry, but it's something that Mr. Howard has regularly represented us for in the past. This year, they are going to be in Nashville from October 4th through the 7th. So I think we have a little bit more room if there's other members that are interested. So first of all, we'll need a nomination, or excuse me, a vote to approve travel for either Mr. Howard and or other members. And of course, if there's any comments to that regard, that would be welcome now. We don't have an agenda yet. That typically doesn't come out till a couple months in advance. But we're looking forward to hosting the Nakara Conference this year, and I'll be giving the opening remarks on the first day of official business. So I'm looking forward to that opportunity as well.
The conference is in October, and I rotate off of the board in June, and I think Angela is probably already rotated off. So likely there's going to be some new members come on before the Nakara Conference. Do we need to vote on it now, or should we go ahead and get our request in for financing?
I think that that's probably wise to we could wait until maybe the next meeting and see if we have any appointments onto the board, and then revisit at that time. Mr. Holden and Mr. Hellman, is that something that you would be interested in entertaining at our next meeting?
Yes, that's fine.
Okay, that sounds good. And just be thinking about that too. If you have an opportunity to look at your calendars, and October 4th through 7th looks like something that you, and it doesn't have to be every single day. That is the benefit of having it, in our backyard this year. If you can make it to one of the sessions or one of the days, that might be something to consider as well.
It's been very good. Glenn, we were in Dallas, Seattle.
Seattle,
We
yes,
were in
sir.
Seattle together, and it's a very good conference.
It was
A lot of good information.
a lot of good stuff came out of that. NMLS was one of those items, something that we'll discuss in new business after the legal report. Thank you, sir. All right, so then we'll just table that until we get a couple more appointments, and then perhaps vote on representation then.
Okay.
All right, for the legal report.
All right, so I'll just read the complaint number and then the corresponding number on the report. Number 1, 2019-083771. Number 2, 2019-084151. Number 3, 2019-085471. Number 4, 2019-086611. Number 5, 2019-088051. Number 6, 2019-091081. Number 7, 2019-91. Number 8, 2019-089961. Number 9, 2019-091901. Number 10, 2019-95141. Or correction, 2019-095141. Number 11, 2019-087051. Number 12, 2019-087731. Number 13, 2019-096191. Number 14, 2020-000391. Number 15, 2020-000751. And number 16, 2018-03-5711. Number 17, 2018-04-5811. And that concludes. There's a couple that I marked on there. They all have recommendations, but I believe there were 2 that I marked for discussion just because they were a little outside the norm of our usual complaints. I believe the first one was number 9, 2019-09-1901, and then number 6 was the other one. Both of them sort of deal with the same thing, so we can take up number 6 first. Not sure if anybody had any real questions about sort of the nature of the complaint. Sort of my thoughts, sort of compared to what we do with other boards, is when we have some kind of pending criminal, or in this case criminal litigation, or in civil litigation, sometimes we place it in a litigation monitoring status where we don't close the complaint, but we also don't take any action on it until the litigation is resolved. In this particular instance, in number 6, we could simply just close the matter if the board doesn't believe that the issues in the board or the issues in the complaint rise to the level that we should really have any genuine concern about. You'll note that none of the allegations arise in Tennessee.
But they're licensed in Tennessee.
Correct.
I think we ought to keep an eye on them. Isn't there something in our statute about moral turpitude?
Well, we could close and flag the matter, which means that the complaint would close, but the license would be flagged. That way, when they're up for renewal, and looks like the renewal is in 2021, at the end of 2021, then that would, could precipitate a potentially an interview, or um, we couldn't deny them the renewal without having a formal hearing, but at least it would stop it would sort of be a significant act prior to just, issuing the renewal.
How did you get to know about it?
Well, I think, Bob, did you find the information when they submitted a renewal? Yeah. And so between that and then going to, there's stuff online that you can just find about, most anything, this included. And at I believe the attorney for the licensee is, saying that they're just sort of at the starting stages of this. So we just have an indictment. There's been no, so.
Counsel, because we're in the starting stages and because it's in federal district court, wouldn't it be possible to just monitor this through Pacer and, check it every 30 days to see where it's at, and maybe let it work its way through that process before we have to make any kind of decision on it? Would that be possible?
We could do that. And that, like I said, again, that would just go into, that would put the complaint just in just a litigation monitoring status.
Or you can close and flag. Like
Or we could close and flag. The only difference being that if we close and flag it, we're when I say the legal division probably is not going to be looking at it every 30 days, although we probably could just informally. I mean, looking at Pacer is something that's 10 minutes or less than that to process to get on and whatnot. So either one of those.
I think we need to keep an eye on this, and if depending on what happens, if he's collecting in Tennessee, if he's working for our clerks here, then we need to be aware of him.
And of course, the CEO may have recently retired, so I mean, arguably you probably have somebody new that's at the helm now. But at the time that these allegations, were made, the CEO that's charged was, the CEO.
And number 9 is pretty much the same thing.
The same thing, even though I believe in 9, it actually may relate more to, well, I mean, assuming the allegations are true, the robbery or fraud and robbery allegations were dealing with the Commissioner of Insurance, which I guess would be roughly the North Carolina equivalent of this agency. So this might be more of a this would probably be more than we want to monitor versus the other one. But we could also do the same thing as we did before. Close and flag is one option. Litigation monitoring is the other option.
Which do you prefer?
Well, from as a practical matter, closing and flagging it, the full-time staff that we, including Glenn and Bob, anybody else, once the complaint or the license is flagged in Core, and Core is it's the database that we keep track of all licensees through. It would show, okay, there's a flag here for some reason, even if we didn't see the flag again until like next year, and then it could be reopened, and then there would be some narrative in there that would say, okay, so as a result of the February meeting, we decided to flag these people, and then we could then get in touch with their representative and to ask, what's the status of the case, or do you all intend on renewing, that sort of thing. So I guess closing and flagging is the easiest one. Litigation monitoring would, however, keep it more on on the legal side's radar.
What's your choice, Dennis?
Closing and flagging really, I think, is the
is as good as any?
As good as any, because
All right.
it can be. I mean, because it's closed doesn't mean that it can never be reopened.
Okay. Let's do that.
Okay.
Just do one motion at the very end, gentlemen. Do we have consensus that the 6 and 9 will be closed and flagged then?
Yes.
Holman agrees.
Okay.
Yeah, that's fine with me.
Okay.
Chair agrees. Number one, Dennis, is this agency in Tennessee? Is he licensed? I mean, reside in Tennessee?
Well, let's see. Well, they've got an application. Bob, you know if they have an application. I know they stated in their response that they admit to being unlicensed and they've obtained a bond with a view towards getting a license, but they haven't been granted one yet. Okay. But as far as where they're physically located, I don't know. But they're attempting to get a license. My guess would be probably not. As many of these folks tend to not be.
I think it's been generally the board would do a consent order, a $500 fine in lieu of a consent order. Is that changed to $250 or?
500 is fine. Yeah, I mean, in fact, 250. I think the reason I might have gone, with half that was in light of their application, and Ms. Thomas has just shown me where, assuming that Google is accurate, which sometimes it is and isn't, they do appear to be out of state. They're physically located in Georgia, so bordering, but not within the borders here.
Chair, did you want to do a $500 on
Yes,
that
sir.
one? Okay.
Yes, sir.
I'm
sorry.
just recording those as we go. Then I'll record that as well. Then okay.
And not to make things more complicated, but on number 5, and the board may have already seen this, I kind of gave a buyer's choice there, either a letter of warning or a consent order for the $250. And the reason being I was sort of split on this was that we don't really know. It appears that the complainant lived in New Jersey, and the respondent has a New Jersey license, and then at some point the complainant moved to Tennessee. Of course, the respondent didn't know, and they continue to call them, and then of course we have the complaint thereafter. So yes, it sounds like they were contacting a Tennessee resident, but it was only after they moved here from New Jersey.
I think a letter of warning is more appropriate.
Okay.
On one like this, that can happen pretty easily.
Yeah, I totally agree.
Okay.
With the portability, cell phones, and so forth, it's really hard to keep up with where people are at the exact moment you call them.
Thank you for your comments, Dan. I'll record that then as a letter of warning.
On number 7, it says the respondent is not a third-party collection service, rather a law firm or something else. What could a something else be?
Well, I think I probably just threw that in there as sort of just a kind of my own term of art. I don't know whether it's another collection agency that or one of these. Well, they don't call themselves collection agencies. They call themselves mediation services, where they might actually be engaged in collection, but they don't refer to themselves as such. That may have been what I was thinking about.
I think we need to know a little bit more about what this is. If they're not a law firm, I don't know what a mediation. I know what a mediation company does, but I think they're just trying to skirt the law. Maybe ask them a little bit more about what their business model is. It's appropriate.
We can certainly. I mean, they responded, so I think I just put that last line in there, that if they are if it ends up being a law firm, then it would be outside the
Right.
the board's jurisdiction. But yeah, that's just my guess. And just for everyone's clarification on 11, that was a situation where it's a licensee that just didn't respond, and potentially we might be back here in whenever the board meets again, and they may have actually sent a response that maybe wasn't processed. So um, as of today, we never received a response that we have record.
On number 12, is the respondent alleging that he is a collection agency?
I think what I recall with this, they appear to be acting as a collection agency, but we never got any kind of response from them. As you said, as I pointed out in the narrative, no response has been forthcoming from the respondent. But if assuming that the complainant is accurate in his recollection that the respondent was a collection agency, and we have an address, I suppose, for them. Um, but no, I don't know that they themselves have identified as a collection agency.
Uh, we don't. So he hasn't responded to us.
Correct. But he's unlicensed, so we don't have that
We don't have that
authority to say, well, because you
Yeah.
didn't respond, then that
Yeah.
in and of itself is a violation, right?
We'd like to know more about this guy. If he's an agency, if he's a collection agency, I wonder if the complainant can send us copies of those collection notices that he got.
I think we've got something from them. I mean, sometimes we only get just our standard complaint form, but I think we may have gotten some kind of notice that this respondent provided. But
If we do have the copies of those collection notices, it would tell us right away whether they're a collection agency or not, and it would give us an address, I assume, uh, to like this company. And what would we normally do when one doesn't respond like this?
well, again, we don't have any leverage that we would have with a licensee for no response. Um,
Let's assume from the appearance of the collection notice he is a collection agency. Then we do have the authority to
it would just be unlicensed activity,
unlicensed
assuming that it
activity.
really is.
And failing to respond.
Well, just the unlicensed activity.
Yeah, because he's not licensed, we can't.
Right.
Okay. Yeah, let's, if you will, let's look into that one a little more. It's the only comments that I have on the legal report. Thank you, Dennis.
Mr. Holden and Mr. Hellman, did you have any further comments on the legal report?
No further comments from Hellman.
I don't have any either.
Okay. Let me give you a summary of the consensus noted so far, and as you're tracking along, let me know if that comports with your understanding of what the consensus is in the form of a motion. First of all, number one, we have a consent order of 500. Number five, the board opted for a letter of warning. Number six, that was close and flag. Number seven, the board would like to represent once more is known. Just more information obtained on that one. Number nine, the board decided to close and flag that one. And then number 12, the board would like to represent that once more info is obtained there as well. And then, of course, the rest of the legal report, the board opted to accept legal counsel's recommendations on those. If that comports with the board's understanding, a motion would be entertained. Do we have such a motion?
Yeah, I move we accept the legal report with those changes.
All right, Mr. Hellman has given us a motion to accept the legal report with those changes. Do we have a second?
Second.
All right, Mr. Holden has given us our second. For roll call vote, then, Mr. Howard.
Aye.
All right, Mr. Holden.
Aye.
Mr. Hellman.
Aye.
All right, thank you, gentlemen. Then we've taken care of the legal report. Then on to new business. First of all, is there anything that either of you on the line or Mr. Howard would like to entertain for new business?
I don't have any new business.
Okay.
I don't either.
Then I'd like to just give one quick update then for NMLS. We've been in discussion about that for a while now. The board sees the merit in pursuing that and has in various stages entertained the idea of us onboarding, this board onboarding onto that system. NMLS, just to refresh your memory, is the nationwide multi-state licensing system. We had our legal division. They researched whether or not we have the legal authority to onboard by administrative direction, or if that was going to require a rule change or anything like that. And it was determined that we do have the administrative authority to do that. That's administrative function. And so we could pursue with that if the executive management was to be in agreement with that. Just to let you know where we are right now in that stage, we're going to research what extent the cost would be for our licensees by comparing notes with financial services. As you know, a lot of our licensees are with financial services. They've got other license lines that are being managed over there. And the difference in cost would be simply that if they're not already in financial services on NMLS, then that's $100 each year cost or expense there for these agencies. Now, if they're already on NMLS, which I suspect a lot of them will be, if they are on NMLS because they have other lines or they have other out-of-state businesses or out-of-state collection operations, which those states require NMLS onboarding, then if that's the case, then it's really just an application fee of $20, for NMLS. So that cost is pretty minimal compared to the benefit we're getting in response. Financial Services has already indicated that when they first did this many years ago, that many of their licensees weren't too concerned about the cost. They understand that was the cost of doing business, and actually welcome the fact that they could streamline a lot of their application processes, because much of which they would need to apply would already be online. They could share all their financials from, that they already submitted to California or Maine or Delaware, and then we would have access to that instantly. So they appreciate the benefit there now. So we're going to be pursuing that and looking into that, researching that a little bit further. But that's where we stand right now. Is there any questions about that or concerns?
Would the collection service board add the $20 or the $100 to the fee, and then the board, the state of Tennessee, pay the NMLS for it, or would they have to do it themselves?
That would be assessed that would be assumed by the licensee. Now, we'll explore all those different options. If we can avoid having to collect, then of course we're going to do that. Actually, I believe now that you bring it up, NMLS does all the collection. They even do and then they just write us a check. It's how that works. They collect even our fees, our license fee and our application fee. They do it all, and then they just send us a check for all of our licensees. So I think it's going to be pretty simple to onboard.
Even better.
Yeah. And having the fact that financial services has already gone through transitioning everything from their platform to NMLS, we already have the expertise in house with the state to make that as seamless as is possible. So I don't expect that there'll be any real difficulty or gaps in that transition. Any other comments or questions? Okay, well, I'll just keep you updated then and as we go. But this is the beginning of that. So now that we realize we have the authority to do that, and it looks like we have some interest from different layers of leadership to pursue that, then we're going to continue research and seeing what the cost is, and then hopefully I'll have more then in the days ahead. All right, well, that's all we have. Yes, sir.
Just a quick question. How quickly do you think you can get this to a decision point for this board?
Well, the board already has indicated that they were interested in pursuing that. So from a an actionable standpoint, the board is already indicated by a form of a motion.
Okay.
I think maybe about a year and a half, 2 years ago, that they were interested in pursuing that. So there's no more action on our part. It's just administratively now pursuing that and working with financial services and the powers that be. So,
Okay.
and I'll keep you abreast of that situation every step of the way. Okay. Well, that's all we had. Unless there's anything else, I think we can entertain a motion to adjourn.
So moved.
We have a motion from Mr. Howard to adjourn. Do we have a second?
Second,
Is that Mr. Holden?
Hellman.
Oh, Hellman. Thank you, Mr. Hellman. We have a second from Mr. Hellman. For roll call vote, Chairman Howard.
Aye.
Mr. Holden.
Aye.
Mr. Hellman.
Aye.
All right. Thank you, gentlemen. We are adjourned.
Thank you.
Hey guys.